Have you informed the other side?
Yes, Lordship.
Take it. Reply the counsel for the appellate. After 3 weeks, only let me pay. After 3 weeks,
May I pray for a date, Lordship?
we are not giving any date. Register will pick them.
Deeply
Please, your
obliged.
lordship. The concern of other side, lordship.
Always try to understand what my senior esteemed brother is saying.
Yes, Lordship.
Letter of absence is not there. That means in the cause list you will find letter of absence.
Yes.
Lawyers were not there. So that was the query. Correct.
Yes, Lordship. Sorry, Lordship.
No, it's okay. Since you are young, just keep a ear on what the my senior
No.
brother has said. So,
Lordship.
okay.
Deeply obliged.
Yeah, please, your lordship. With the concern of other side, lordship, I beg to mention item number 12, lordship. The conducting counsel, Mr. S. Gupta, is lordship out of station. Kindly matter may be taken after a week, my lord.
Lordship may kindly fix a date. I am representing on behalf of all the private respondents. After 16 August.
It is submitted about that Mr. H. Gupta counsel, Planet Agency. Out of station. As such, what's your good name?
Why would we, my lord?
And also raise for short accommodation and list after a week. Will come after a week.
No, no, please.
Yes, next.
Madam, in this item 12, my name also may be reflected, madam.
Okay.
And thus the government advocate for 151, 150 to 153.
And as for 151, 152 and
153, madam.
yes, and that one. Yes,
May it please your lordship. Lordship, I beg to mention item number 25, your lordship. I appear on behalf of the appellants.
no, Mati.
There's some difficulty on our part to be your lordship. Lordship may take out a matter after a week. Item 25. 25.
Have you informed the other side?
I've informed the standing counsel head, Mr. B. Go, your lordship.
May it please your lordship, with the consent of other side, I beg to mention.
Let the order be passed, ma'am. After 2 weeks, we'll take it. With the report. Yes,
With the consent of other side, I would like to mention item number 24 of today's daily list for adjournment. I am appearing on behalf of MSS Dasgupta for appellants.
have you informed the other side?
Yes, your lordship.
Lordship, I am on behalf of RM Das, respondent number 4.
Report.
Second one.
It is submitted by Mr. S.C.K.L., London Council, appearing for the appellant. That that by document number 2, that is 06/08/2024. You're appearing for whom, Mr.
Lordship, appellant 1, 2, and 3. Lordship, probably item 2, the retable was restored to file on the basis of order passed in
Now you're appearing for whom?
for 1, 2, and 3, appellant number. Union of India,
For respondent numbers?
respondents, we have taken steps. Lordship. Respondent number 1 is
Okay.
ISA Industries, 2 is Rail
Taken.
India Technical, and 3 is General Manager.
On the respondent numbers 1, 2, and 3.
Lots. No, I am appealing for appellant number 1 and 2. We took steps on respondent number 1, 2, and 3 in the appeal lot.
You have taken steps on them.
Lordship.
The basis of list after 4 weeks. No, 4 weeks on a date to be picked by the district.
Much of.
I will. Six tag has it. May I please, your lordship? My lord, we have deposited before the registry, my lord, and the dusty is ready, my lord. We are required to take a fresh dusty on respondent number 4 and my lord 6. My lord, we 2 weeks time may kindly be, my lord, provided to me, my lord. Because the registered post is not clear, my lord, so we are also required to file an affidavit after the dusty, my lord, as per the last order, my lord.
On the prayer of the appellant, Mr. A.R. Bhuyan, Learned Counsel, is allowed to take steps on the respondent number 4 and 6 by justice service
My lord.
to be routed to the registry of this court. Such justice of the personnel service on the respondent copies of notice on the respondent numbers 4 and 6 shall be taken by the appellant by serving a copy of this memo of appeal along with the annexes appended thereto, obtaining their signatures with date in presence of one or more witnesses. Thereafter, the appellant shall file an affidavit on or before 27/08/2024 regarding such service of notice on the respondent of 4 and 6 by the civil personnel list. Register shall list this matter in the week commencing from 2nd of September on a date to be fixed by the
My lord's mind. On type.
Okay, the date is 38.
My lord, my name may be recorded.
You are
Respondent
appearing for whom?
Respondent number 5, my lord, in item number 5.
Mr.
HMR2.
or respondent number 5.
Obliged.
My lord, this is a criminal contempt, my lord. My lord, my lord,
You have
during,
approached the Advocate General.
my lord,
You have approached the Advocate General.
my lord.
Have you approached the Advocate General?
My lord, I have gone through the procedure of the High Court rule. It is required in case of the lower judiciary, my lord, not in case of the minor High Court. Sir. In the day section concern also they verified, my lord.
Sharma.
What is the order?
My lord,
What is the order against which this?
my lord, this is a first, my lord, the order was passed on 19/6/2024 in the
Where is that?
IA.
Where is that?
My lord, this is annex cell. My lord, that page. Page, my lord, 30, annex 2. Notice was issued on the minor condemnation petition for delaying in 14 days. The advocate concerned representing the minor contender were very much present. He received the copy. Time was taken for filing the opposition affidavit, my lord. Returnable date was there. Everything with the knowledge of the advocate as a party concerned. Extra copy was served before the demolition. But with the all knowledge, having the knowledge of the pendency of the case before the lordship, they gone on demolition. All the video clips also there, the photographs also there.
No, where is the order? Where is the operative order against which contempt is alleged?
My lord, the first order that is filed in the WBC, that was, my lord, the annexer.
Page. Tell us the
Yes,
page.
my annexer 18, annexer 1.
Tell us the page.
Page 11%, my lord. At page 28.
Page 28.
Yes, my lord.
Yes. What
Yes,
is the
there are
direction?
18,
Because
my lord.
the writ petition was dismissed.
Writ petition is dismissed, but
Yes.
liberty was given to me.
Where is that?
My
Where
lord,
is
this
that?
is the annexer, same page, my lord, 29, para 20. Then, my lord, I have filed the appropriate petition before the authority for changing of classification. And the DLC meeting that was held on 10/7, that is annexer 3 at page 34, by which my application along with other consideration of the other petitioner that was rejected. And copy of this minute was served on 11/7 on me. On the same date, again, my lord, the petitioner has personally served the copy of the Honorable Court order passed on 19/6 that the matter is pending. And they, my lord, did not listen to these things and came on 12 and demolishing the entire construction and the property of 3 crores more than, my lord, that is destroyed. Even the 2 tenants were there, their property was not allowed to remove.
I'm not being able to follow.
My lord,
You see, this order was passed on 19/3/2024.
my lord.
There's a direction in paragraph 20
Yes, my lord.
that within a period of 1 week, you must apply.
I applied, my lord.
Where is that statement?
My lord, I have applied, my lord. This is order, my lord. Copy of the minute of the that is I annex, my lord.
Where is that? Show us.
That is annexer 3 at page 34, my lord.
Page
34. Yes, my lord. This is number 1 serial number, my lord. I am the petitioner. And My lord, column number 3, that is my lord discussion. And the last para, that was the considering all the facts and gravity of the matter and all, and also seen the discuss the relevant papers, joint verification report, etc. The committee is decided not to
Just a
recommend.
moment, Mr. Mahanta. Yes, Mr. Mahanta.
My lord.
Please come to the order of the court of the learned single judge,
My lord.
the direction.
Yes, my lord.
Kindly read.
The page, para 20, my lord.
Yes, para 20,
My lord,
page
the
29.
page 20, yes, my lord. The above being said, the petitioner is given the liberty to approach the respondent authority for reclassification of the land in question for the purpose of allowing him to use his construction for commercial purposes. If the petitioner
Now
file,
read slowly. Yes.
if the, yes, my lord,
Hmm.
if the petitioner file an application for reclassification of his land, the competent authority will decide the same as per their discretion. If the petitioner applies for the reclassification of his land within the period of 1 week from today, the respondent should take a decision on the same immediately. The notice dated 19/3/2021 shall not be acted upon till the decision of taken in the petitioner's representation, provided it is submitted to the respondent within 1 week from today. my lord.
So if the petitioner filed an application before the respondent number 3 within a week from date of the said order,
Yes, my lord.
that is 19/3.
Yes, my lord.
So time was given up to 26th of March
Yes, my lord.
to file an application.
I file it.
And in the event of filing such application,
Yes, my lord.
the authority, respondent authorities shall not take it till
Yes.
such decision is taken. It shall not act upon the notice dated 19/03/2018.
Yes, my lord.
Now kindly come to page number 34.
34.
This, when the decision was taken,
That is on 10/7, my lord.
10/7.
Yes, my lord.
Then what was the decision taken?
Second, my lord, my application was rejected. my lord.
Application was rejected.
My lord.
When the action was taken by them,
On 12.
so what's wrong?
My lord,
Direction
wrong.
of the court, you just see. Where is the contempt?
My lord, as per the section 3 of 2C of the
What
content.
is the direction of the court?
Direction, my lord,
that
kindly.
if you file any application on or before 26th of March 2023,
To the,
the action shall not be taken on the notice
yes, sir.
that was issued on 19th of March 2018.
Yes, ma'am.
Till a decision is taken.
Yes, ma'am. That is very, I am not
Right.
disputing.
A decision was taken
Yes, ma'am.
on
But
10th of July, and thereafter action was taken.
But-
Where is
but-
the illegality?
But the thing is that, my lord, the single judgment was not the final judgment. I preferred an appeal. Appeal was pending. And the IA was filed on the condemnation. The notice was served to the respondent number 3. Their advocate was present.
Whether the proceeding was stayed.
Proceeding was necessary, but they took the time to file the counter on the IA, my lord. This is for condemnation of petition.
That was the condemnation.
But the thing is that, as per the section 2C, it is a clear contempt. My lord, whenever these things was knowledge with the respondent, and the entire action only to lower the status of the court and to hampering in the admission of judiciary. So this is the as part is definition. It is not necessary that my case was rejected and that will be demolished. Certain things were developed after that.
Where is the order of the court? Anyway.
This is my notice was issued on my notice annexed to
Just a minute, we'll get it.
it is mass prior of the demolishing.
Sharma. On it. the
Where is the original order of 19318?
My lord.
19318, the original order, where is that?
19.6, my lord. This is annexed to a page. But it is started from 30 and relevant portion at 33. my
No,
lord.
no. Original order of 19318 by which demolition was ordered.
Yes, my lord.
Where is that document?
This is one of the annexure 1.
Election one is High Court order. No, not this.
Or this, that notice, my
What
lord.
is order?
Notice is not available right now.
You have a copy?
Copy is not right now available. That is in original appeal, my lord, is there, right? Sorry, my lord.
Mr. Anto,
My lord,
we don't find that there is a contempt. We have
my lord.
tried to analyze the contempt petition and the sequence of events. You see, please, unless you see there is a judgment of the Honorable Single Judge of this court long back, where it says that notwithstanding that a condonation application is filed, but in urgent cases, the injunction can still be granted
But
if
they,
there is a threatened demolition.
but they,
But in this case, a condonation application was filed for condoning on delay of 14 days. And the other side may have come and taken time. We are not disputing that. But still, there was no duty of a standing counsel to tell the respondents not to demolish, because that is something which the court has not ordered. Therefore, let me reverse the role. Let me assume for the time being that I am the standing counsel. I get a copy of application for condonation or delay. Now, please tell me, will I communicate to the authorities that don't demolish?
no, my lord, lordship, so far these things and it is a correct, my lord. On the day of the, my lord, the first day, when the lordship, my lord, the division bench, my lord, they issued the notice on 19/6, the respondent, my lord, the Transport Development Authority, they must ahead, they enter their appearance, and on his fairly submission, that the, my lord, the demolition works has not been, my lord, completed because, my lord, he has not filed the, my lord, the decision has not been taken on the, my lord, classification of the changing of the classification land. So the notice was issued on 19/6.
No,
And the
we are
decision
not
was
concerned
taken.
on that. We are not concerned on that. There must be a willful
No,
and
my lord,
deliberate disobedience.
my lord, humble submission before lordship, my lord. Whatever order was passed by the single judge, it has been already been challenged before the division bench. And division bench, my lord, issued the notice.
Show us any authority where it says that it should
My
consider
lord,
the
this
stay.
is issued on 19/6, and they have taken the decision on, my lord, 10/7. It is much after. So that is with their knowledge that these things is happening in the court, my lord.
Any authority on the point that issuance of notice in a condonation application will operate as a stay?
No, my lord, generally, my lord, the convention is this one, unless and until your condemnation petition is decided, stay will not be granted, my lord. This is a convention of the court, my lord. This is always happening. So, my lord, this my humble petition is this, my lord. The whenever matter with the, my lord, as per the Contempt, my lord, Court Act 2, Section 2 of C, it is clear contempt, my lord. Lordship, have a look on the contempt, my lord, definition, my lord. To see, my lord. This is a clear definition, my lord. It is not necessary that they are not giving any, as the demolition was not said, so they cannot, they will not come for the demolition, my lord.
Kindly read.
My lord, definition 2, my lord, this is a C, it is a criminal contempt, means the publication, whether by words, spoken or written, or by sign, or by visible representation, or otherwise, or any other matter of the doing of any other act whatsoever, which scandalize or train to scandalize or lower the authority of the authority of any court, or prejudice or interference or train to interference with the due course of any judicial proceeding, or interference with the train to interfere with the obstruction or train to obstruct the administration of justice in any other manner, my lord. My lord, here, my lord, their intention is to, my lord, first at the lead appeal. And they are with the very knowledge that the condemnation petition was issued on them. And moreover, the video clearly is there. They spoken how the circumstance.
Mr. Monta will pass the order later during the course of the day.
My lord, I want to submit one thing, my lord, that there are video, my lord, clips are there, where the, my lord, lordship can hear the, what the comment, my lord, the circular officer made on the, my honorable court, my lord, order. How they treated, everything was there. And the lordship have a look at page 42. This was the circular officer, my lord, wearing the spec. He was the circular officer, I am showing the order of the honorable court. He refused to accept. Then, my lord, the next page, again, lordship will come. This is, my lord, page 45, where the, my lord, contempt number 1, that was shown to him also. All video clips are there.
Incident.
Lordship, pass on.
Wait to the motion. As a condonation application is there, delay of 15 days. My lord. Impugn order, my lord, finds in the connected writ appeal, it starts from page 54. Well, I may indicate in a nutshell where things went wrong, my lord.
Take your seat, Mr. Bani.
Lordships, my lord, page 60. I'm pointing out.
Mr. Banik, any valid reason to interfere with this order?
My lord,
Any valid reason to interfere? Tell us. We can understand you have filed an appeal because the petitioner is aggrieved by this order. But tell us, on the legal side,
she
is
retired.
there
and
any valid reason to
Well,
interfere with this order?
the petition, I thought so. The person retired on 31st of July 2024.
We have seen that.
No, no, I'm just indicating it today we're in August. The entire thought process was planned on two factors.
See, the finding of the Honorable Single Judge or learned Single Judge is very clear. Two things. The Honorable Apex Court has upheld the law, the rules of the SEBA.
Yes, yes.
There's the borderline is 3 years. It's not a limitation. It is at the cutoff line or giving touch. And secondly, the as been held by the Honorable Apex Court, the birth certificate which at a belated state which you could trace out after the death of the father of the petitioner. It's a belated stage and it's not a public document.
There, but I'm on. Now, what I was submitting with that. In fact, correct. 3 years.
No,
that
before
time
before
it
you
has been
submit,
appended.
before you submit, we were very impressed with para 18,
Of
5 lines from below. Para 18 of the impugn order
no, no.
is 61. 5 lines from below. I'm not reading it. I'm just pointing it out.
Clear finding. Instead of 65, why I have selected 66? That is also issue.
Clearly submit.
Correct.
Clearly submit.
Now, I know what the fate is, but if I may,
Don't say fate.
the address your
It's
lordship.
not a fate. We're in the court of law.
No, no, if I may address my lord, at least my client will go down to the satisfaction that the lawyer has said something. That's what. My lord, by 66 and 65, by 65, I lose a year. By 66, I gain a year. So therefore, difference of 66 in the SEBA is not to my advantage. This part was not taken care, not considered correctly, if I may say. Correct. I ought to have given 65 because I got to know that prior to submission. Therefore, 66 would be wrong, so far as I am concerned. Now, if I take it the other way, what do I gain out of it? By putting 66, I lose a year. By giving 65, by putting 66, I lose. But I'm praying for 65 here. If I pray for 65, I further lose a year. If I go by 1965, then, my lord, my retirement would have been sometime around 25, 2025. If I go for 1966, sometime around 26. So, by praying for 65 in this court of law, I'm actually being frank and open enough. Now the point comes, which we have not stated, but in one paragraph we have stated that although we went to the authorities with the documents, but they did not accept it, therefore we made a full record, because if at least whatever is there is there. Now this part was not considered in the correct perspective. Even if considered, I might not have had a case, a different issue altogether. Second part, what weighed more, and in common parlance should rather, that at the fag end of retirement, 42 years from your epic, you have tried to bring in a change, which may give you some other benefits. So that my most respectful submission would be, that all persons are not so blessed to be in service in security. With that comes an age of retirement. Some people are like us. We live life without the date of retirement. If I want to change, correct my date of birth, would the age of 60, 62 be an embargo? The answer would be no. Therefore, the age of 60 or the proximity of reaching the age of 60 ought not to have any bearing on my application. Only a thing would be 3 years from matriculation. Admit card. That's my second statement, submission which I'm making. All people are not in service. So therefore, attainment of 60 or near to attaining 60, unless I'm praying for some service benefits. Yes. If I'm not paying for service benefits, but for a connection simpliciter of my date of birth, because date of birth cannot be changed, it can be corrected. Name can be changed and corrected. This factor also was not appreciated in the correct perspective, if I may say, or could not be explained properly, if I put it that way also. The third, the 3 years part, if I may be permitted to address on that. My lord, absolutely the law is settled. If I want a correction of my date of birth or whatever particulars in the admit, 3 years is the limitation under the rules or regulations affirmed and upheld by the Honorable Apex Court. But that case was also discussed in a case by the Honorable Apex Court in cases of correction and change. That is indicated in the judgment itself. We have placed it. If I may permit it to refer that. Before I refer to that, I just broadly indicate the case before the Apex Court was of CBSE candidates. Many candidates, some had wanted a change of name of the parents or correction, some in respective date of birth. The question came in was whether the bylaws or the regulation had a time frame and if it could be permitted beyond that. Discussing the provisions of law and also the judgment which the Apex Court concerning the SEBA, appalling incorrect. SEBA was set in the correct in the facts of the case. The Honorable Apex Court brought a distinction. The distinction was that two categories. If someone would want a change based on school records, then the limitation would come in. Meaning thereby, if I pray for 66, whether I have a case or not is different, but I'm just examining. If I pray for 66, which is based on, I was 64 in the admit. If I pray for 66 and 66 is based on school records, then I'm hit by the limitation of 3 years and the Apex Court judgment will also come in. But in cases where we want a change or a correction, not based on school records, but differing from school records, then the limitation would not come in. Of course, there would be mechanism to see the correctness or validity of the request to the PSO made, and the examples were taken, the Aadhaar card, the passport. The two fall from two different legislations to which you to follow, and there the mechanism.
Other examples also, in one of the cases, the person wanted to have the mother's name included because the father demanded. So therefore, that was permitted by the Supreme Court.
In those contexts, the judgment which followed in Jigyadev case was that the change, if it referred or relied upon the school records, you are hit by limitation. But it'd be too far-fetched to say that I am praying for a change in my name. Tomorrow I want to have a name change for various reasons. And I want that name to be in my matriculation certificate also corrected. Am I barred by the thing? Maybe yes or no. That answer was given. The answer is no. There's no limitation effect. But if I want to say the way I spell my name or my surname or whatever, or date of birth, whatever is the school record says something and the matriculation says slightly different. And I want to get it corrected. 3 years gone. In that context, all what I was praying before this honorable court, I am retired. That 42 years after you have prayed would not have any bearing because I'm praying for a simpliciter change. And my 66, which I sworn there, and 65, which actually were, I still lose a year. Now I'm retired, man. All what I want in life is that correcting to be reflected. I could have understood midway service also thinking would have changed. That is my case, nothing more.
No. Dismissed.
Gotcha. But only might not be indicate that the person has retired by now.
Well, I approve of it, but tomorrow he may get another piece of papers opening the trunk of his father. I think he should not.
Madam, can you also indicate in the meantime the person retired from service?
Yes,
31st of July retired from.
Yes, we have already calculated.
Well,
31st of
July.
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 July is 54%. Work more than 31 years, 5 months, 15 days. What else you want? Why at least
Obliged, man.
Dismiss for. My lord, and I have for only 1 day of delay, my lord. The difficulty is, my lord, the private party is there, my lord.
You have to issue notice.
My lord,
You have to issue notice.
my lord, my lord.
You can serve by the state.
Yes, yes, my lord, that can be done.
Private party,
Right.
who is there?
My lord, the
one issue पड़ता है
respondent one, Razak Hussain was the writ petitioner, my lord. He is the opposite party number 1 here, my lord.
1 and 9 also.
8 and
1 and 9.
Yes, yes, my lord.
When is
The-
income?
8 over.
8 also.
8 also. No.
It is not a government.
Where is the headmaster? 9 to Kuntu, 9 to Amin Hani.
It is not a government institution.
No, but
It's
No.
not.
It is not a government institution.
No, my lord, it is a provincialized school, my lord. So he is a government teacher, my lord. Lord, in fact, respondent number 9 is being represented by the present appellant, my lord. That 9 is not required, my lord.
You have to strike it out then.
Yes, my lord, because that 9 committee has been set aside and interfered with, my lord. Not a necessary party, my lord, here. 1 day.
You are the president.
I am the president. I was the president, my lord, before the interference.
Presently, who is the president?
My lord, thereafter, my lord, it has been directed to be looked after by the officials, my lord. So officials are now looking after, my lord.
Okay. The writ petition now, when this writ petition was filed, you are the president of the.
Yes, my lord, challenging my presidency, my lord.
Challenge was with regard to the selection of the president.
Selection of the president as well as the approval order given by the district elementary education officer, my lord.
Not Mr. Yaru here, counsel appearing for the petitioner. Sorry, applicant. Plus applicant. And so what are you appearing for whom?
Respond now 4.
Yes, ma'am, you are appearing.
I am.
7, my lord. Kedar.
MS Kedar, Standing Council. Education Department
Element.
or respondent number opposite party,
6, 7, and 8. My friend can appear, my lord.
3, 6, 7,
2, 3,
and
6.
8. Any government advocate, please come up. Also heard Mr. S. Bora, Standing Council, SSA Assam for the respondent number 4. And MS, such and such. For respondent number, opposite party number, let's. The respondent number 1 finally connected writ petition WPC number 1052/2024 challenging the constitution of the managing committee of
That, my lord,
Bhangi ME Madrasa
Mal.
Baladoba Bhangi ME Madrasa, Bhangi
No, respond.
Part 2, Village Bhangi Part 2, Baladoba, District Bhubudi, a provincialized upper primary school wherein the present applicant, wherein the said committee was headed by the present applicant as its president. By judgment in order dated 2002-2024, not really, which is the order passed by the chair.
My lord, judgment and order dated 18/6/2020.
By order dated 18/06/2024. Passed in WPC number 1052/2024, prepared by the respondent number 1. Directed the state authorities in the elementary education department to constitute a new school management committee for the said such and such school. Being aggrieved, the applicant was the president of the said school managing committee. Preferred to conduct the appeal with a delay of 1 day. Hence this application under section 5 of the limited select to condone the said. Issue notice. It is submitted by Mr. Muya, counsel for the applicant, and MS K. Das, Learned Standing Counsel, Elementary Education, that presently the school managing committee of said Barbhangi Ami Madrasa is managed by the inspector of schools or DEO,
DO, my lord, district.
by the district elementary education officer, Dhubri. And as such, Mr. Bhuya praised for striking off the respondent number, name of respondent number 9, the school managing committee. Say, parallel. The opposite party, respondent number 9, the staff of the cost that. It's on. 3 weeks. And such and such and such, no further. Additional services next time. On or before 13th of August. Of the necessary activity. Petition, applicant, petition. Applicant is also, applicant shall take steps. Submission of notice on the private respondent number 1 by registered post secretary. On a property.
Along with Dasti may also provide.
Applicant is also allowed to take steps on the respondent number 1 by the duly person service. Please issue notice returnable by 4 weeks. Please check.
Obliged.
Mr.
There is a delay of about 128.
Mr. Vuya, just a minute. Mr. Vuya.
Yeah.
Sorry. You have not, because normally, as you know, we pass an order after filing of such justice service, you are required to file an affidavit.
My lord, we'll
Will
file
be
one. Yes.
Yes, Mr. Prakash.
Obliged.
There is a delay of about 128 days.
Delay of 128 days.
8 days. So at this stage, my lord, perhaps notice may go.
Ms. Sharma, you will take accept notice
Yes,
because
Lordship.
all are
Official, madam. State response.
Lordship, almost it's a contented order. It looks like.
review petition. Review. Go to the right now. Yes, Mr. Purakaster, will you kindly tell us which is the writ petition you are talking about at page 170?
170.
Yes.
This is my writ appeal. Page 170.
Did you prefer any writ appeal?
Writ appeal, I prefer writ appeal against the first writ petition. And there was, my lord, kindly see the next page.
Just a minute, Mr. Purakaster. Kindly tell us the first writ petition that you preferred in the 2008, 267,
My lord.
2008.
My lord.
Did you prefer any read appeal?
Yes,
Which is that?
my lord, that is at page 70. 170, sorry. Writ appeal number 160 of 2023.
That is after the division bench order.
No, after initial writ petition was dismissed, then writ appeal was preferred. And
Your
writ
writ
appeal,
petition was allowed.
no, there are my lord, three different writ petitions. Initially, I was dismissed from service without any dependent processing. Then direction was given to reinstatement.
Hmm.
Then one more writ petition was preferred, my lord, regarding my salary, and pensionary benefit, etc. And my
Where
lord,
is
that
that? Where is that? Where is the order? One sixty-six is the order.
160 is the, my lord, 166. There is an appeal in opposition, 160.
Okay, this was not heard.
Yes,
And it
my-
was dismissed, so you preferred a read appeal.
my lord.
Okay, thereafter,
Thereafter, my lord, liberty was given to approve the single bench
Hmm.
to file a review.
Hmm.
Review was moved, my lord.
Hmm.
That was rejected.
no, against the, just a minute. After this order of the learned single judge passed in 2008,
My lord,
when did you prefer the next writ petition? 2019.
2019.
What was our prayer there?
My lord, prayer was that, my lord, salary, pensionary benefit, nothing was fixed, my lord, according to, my lord, rules. And my lord, whatever benefit I was derived under 5th and 6th CPC, that was also not considered. Abruptly, they made some calculation, therefore I was agreed by that. Then writ petition was, my lord, dismissed for non-prosecution.
Do you want to file any objection regarding the delay in preparing this review petition?
No, this is for the, oh, no.
Lordship, first Lordship, what I found that Lordship, the document that they have annexed regarding the delay Lordship, that is the prescription Lordship. Here age is 73, but in the affidavit it is 69. That is what I have gone through.
There.
Yes, Lordship, prescription is age is 73 and affidavit age is 69.
When it was issued, that prescription,
Prescription is 2024.
which date?
One is March, one is June.
Page.
Page 50, 54 and 55.
Okay. The affidavit is at page 52,
Lordship.
69 years.
Yes, Lordship.
That is in which,
Name is also not full. DD Colita is written and age is different, Lordship.
page,
54, 52.
73 male,
Yes, Lordship.
54.
55 also.
And then, next
23.
page 55,
51.
73. Male.
No, no, what writ petition is given? What writ petition was given?
On the short
File to-
name is written and that age is a different.
Well, I will have to, my lord, check up, my lord, what is the age mentioned in writ petition. Because that writ petition is not annexed, my lord, I think. But if appeal in opposition, this one, right? Appeal in opposition is 2 months, I think. It would be petition.
Please come to your own application.
68.
Straight away come to page number 159,
150,
9 of the writ application.
159. Yes,
What was your age?
that was, my lord, 68.
Which year?
2019.
So
So it's 19 and now it is 24.
how many, what will be your age?
5. 68, 5, 73.
So what you have given in page number 52
52.
in the application,
69.
dismiss, right?
Hello.
Why?
Hello,
Wrong
then my-
submission made in the affidavit.
Yeah,
Why should
there
we
is
entertain?
perhaps my lord, some type
No
of.
perhaps. Where is the question of perhaps?
Mr. Prakash,
My lord,
just like you, I also believe age is just a number.
my lord, that might be my mistake. Maybe.
Don't know.
No, we don't know.
My lord,
Petitioner,
logically,
the applicant has signed it. Dharani Dhar Kolita full signature.
that's right, my lord.
So you cannot have benefits this way.
My lord, let me file an affidavit, my lord,
No,
saying that
No, you can't, you can't.
That is cannot be, you cannot now rectify
there
that.
is a my lord, mistake, my lord.
No, cannot be. He has
My lord,
signed
I
it.
will perhaps, my lord, I have oversight it, my lord.
How can
I have
you?
ignored that.
It is an affidavit shown by the
I have-
applicant.
My lord, he is 73 years, my lord. Apparently, it appears from other earlier writ petition. Earlier writ petition, he is, my lord,
You
69
do not know.
years.
He has signed it.
Let me, my lord, at least have an opportunity to clarify by filing an affidavit. Record will show that, my lord, he is above 70, my lord, around in and around 72, 73 years. কি করা তোমাকে দেখো না 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 মেডিকেল 73 years.
One more thing, if lordship permits me, although in the first order, the dismissing the writ petition, lordship, it was not written detailedly, but it was dismissed, but it was not dismissed for default. The counsel who was appearing in the writ petition had submitted an application before the registry that the file had been taken away by the petitioner long back, and he was absent for 2-3 days. And on that basis only, although it is dismissed, but it was taken back.
But he did not.
It is ultimately passed on.
Yes, Lord.
That-
Yes, and in the review
That
also,
purpose, the review was allowed.
Yes.
And so since that order is not under challenge,
Yes, sir.
we have to accept the review. But we are
What
here-
is, Mr. Prakash, what is the date when the seventh pay commission came into effect?
7, my lord, I think, my lord, 1/1/2017.
2017.
Yes.
So a person who is retired in 2008 will get 2017 pension.
No, I am not claiming 17. I am claiming, my lord, 2005, 2006. 2005, that was with effect from 1/1/2008.
That would be hopelessly barred by limitation.
Against that, you have preferred a repetition, appeal in 2019.
writ petition again, yes.
Yes, again.
So
My lord, there is a question of law, my lord, whether it is a continuous wrong. If it is a continuous wrong, then a delay will not come. My right to claim, my lord, certain benefits accrued under certain, my lord, policy decision or certain, my lord, pay commission report. And once it is not paid, it is a continuous wrong on their part. And if it is a continuous wrong,
To withdraw this appeal and the interrogatory application.
my lord,
We can't allow you to amend it.
my lord. And let me file a fresh one. With an affidavit, specific affidavit, I am shouldering the responsibility. There is some mistake on my part, but I could not have, I ought to have been more diligent. I'm not blaming anyone, my lord.
Heard Mr. A.K. Purakaster, counsel appearing for the applicant appellant. And I'm Aswini Sharma, learned deputy.
CGC law.
For all the respondents number. Opposite particular. 1, 2,
For all Lord.
7. Because of the discrepancies in the inadvertent discrepancies. That Ms. P. Sharma, learned CGC, has pointed out the discrepancies relating to the years of the applicant as mentioned in the affidavit of this application. Vis-a-vis the medical certificates dated 29/03/2024 and 2706/2024 annexed to this application, is a medical prescription, medical certificate of the applicant annexed to this application. Accordingly, the counsel for the applicant, Mr. Procast, on instruction, praised for withdrawal of this application along with the memo of the appeal with liberty, to which the counsel for the respondents have, opposite parties have not. According, this application stands dismissed on liberty as per or.
Apply stand get.
We'll come back after a few minutes.
Yes, Ms. Gayan.
My lord, here we have challenged the order, page number 114, my lord. 114, but relevant portion is 122, my lord. Para 13. May I?
If out of the same evidence,
Yes, my lord.
other repetitions were allowed and no appeal was preferred,
Yes, my lord.
then why we should entertain this appeal?
My lord, kindly see, my lord, what is the SARS, my lord? SARS is in page number.
Two charges are framed.
Yes, my lord. Page
In
number.
respect of both the charges, the learned single judges made a mention that on the same facts and circumstances, the other repetitions were allowed.
My lord, kindly see, yes, my lord, thanks, sir, but kindly see, my lord, page number 66, that is the SARS, my lord. SARS, page number 66 of retail.
No, no, we are on the issue of judicial discipline. You see, once a repetition is allowed,
Yes, my lord.
on the ground of parity, the second repetition must get the same relief.
Here, my,
Because in the first repetition which was allowed,
yes, ma'am.
no appeal was preferred. In one case, appeal was preferred, writ appeal is mentioned,
Yes, ma'am.
writ appeal 120,
Yes, ma'am.
and that was also against you.
Against the argument, that we
Therefore-
was against the argument. But kindly see then, madam, we have the petitioner has preferred an appeal, sorry, madam, review, that is, the order is in case number. Order is in case number 14, my lord. Review, there is
14.
one mistake, 14, my lord.
Yeah, that is the order we are.
Or the, my lord, kindly, my lord, page number 22, may I read page number, para 17, my lord?
Just a minute.
After this WPC 4518
Yes.
at page 114,
Yes, ma'am.
you preferred this review petition.
Review petition, review is only for, my lord, there was a mistake on the, that learned single judge that mentioned that he crossed the age of superannuation. That is why the review petition was preferred, my lord.
And review petition in page number 20 in that para 17. May I read my para 17?
Para 17 is a
Review petition.
reproduction of what is there.
My lord, in view of the discussion held above, this court considered it appropriate to grant similar relief that has been done by the coordinate bench WPC number so and so. As such, in view of the interference by the court of inquiry report dated 16/9/19, as well as order of dismissal dated 30/10/2000 passed by the disciplinary, the petitioner is directed to reinstate as a constable CISF with immediate effect, and service benefit applicable to the petitioner will be released by the authority as per provision of the law. The petitioner will be given the notional benefit of his service, and seniority will also be protected, my lord. And also the
Just a moment. Ms. Gahan, you see, what we understand from this writ petition is that
Hmm.
the present petition, the respondent herein, along with another person,
Yes, ma'am.
had manhandled one of your officer, SIEXO-RG Karnan,
Yes, ma'am.
correct?
Yes, ma'am.
So these two people were charged. Insofar as one is concerned, he was directed to be reinstated.
Yes, ma'am.
How can we pass a contradictory order in this
Yes,
case?
my lord, he is directed to reinstate, my lord, along with that notional benefit and the back wages, my lord. My lord, kindly see page number.
Ms. Gahan, my brother is asking you, for the same offense, two persons were charged.
Yes, my lord.
Proceeding went against them.
Yes, my lord.
Same evidence,
Yes, my lord.
everything. The other person was
Yes.
reinstated in service, right, by the
Yes,
order of the
yes,
court.
ma'am.
Now, as a judicial discipline, this order has also been passed in favor of this particular
Yes, my lord.
applicant.
Yes, ma'am.
Now, your appeal was dismissed
Yes,
earlier.
yes, my lord.
Tell us what
My
the
lord,
reason for
lord,
interfering with this order.
My lord, in between that, he filed this writ petition in 2008, my lord, and in between he was convicted, my lord. Kindly see the page number 116, my lord, this writ petitioner, my lord. Page number 116, paragraph 2, my lord, of the single judge order, my lord.
Hmm.
Against the said dismissal, the petitioner initially approached the High Court of Allahabad by filing the writ petition being number so and so by order dated 15/9/2006. The Allahabad High Court dismissed the writ petition on the ground of lack of territorial jurisdiction. Thereafter, petitioner approached this court by filing instant writ petition. However, during the pendency of the writ petition, he was convicted by the criminal court and put behind the bar. As a consequence thereof, he could not instruct his counsel, and the instant writ petition came to be dismissed due to the non-prosecution by the order dated 28/11/2013 passed by this court. After his acquittal, petitioner took the step for restoration of the writ petition by the order dated 15/11/2021. My lord, we are agreed by that, my lord. The benefit that has been given along with the reinstatement, my lord. He was under and behind the bar, my lord. And there is one judgment of Supreme Court also, my lord. And he was dismissed in 1996, my lord, and after 28 years, my lord. My lord, kindly see last page, my lord, of this paragraph 11, my lord. In the case Synthetic versus KP Agarwala court dealt with the issue regarding the entitlement of delinquent to claim continuity of the service and the consequential benefit in case of the reinstatement as follows. 17. There is also a misconception that whenever the reinstatement is directed, the continuity of service and the consequential benefit should also follow. As a matter of course, the distress effect of granting the several promotion as a consequential benefit to a person who has not worked 10 to 15 years. Here, my lord, 28 years he was not in work, and who does not have the benefit of necessary experience of discharging the his duties and function promotional post. He is seldom visualized while granting the consequential benefit automatically. Whenever the court or tribunal direct the reinstatement, they should apply their judicial mind to the fact of the circumstance to decide whether continuity of the service or the consequential benefit should also be directed. We may, in this behalf, refer to the decision of this court, my lord. Here, my lord, in this case, he was not in service for 28 years, my lord.
You see this respondent,
Yes, ma'am.
what is the date of his superannuation?
His date of superannuation is, my lord. I think he is now 50, above 50, ma'am, because he is about 51 years, my lord, in page number 17. 51 years, my lord.
Where?
That is in page number 17, my lord.
17.
Yes, my lord.
Ms. Gahan, let us understand again.
Yes.
You are aggrieved with only one part of the order which relates to back wages.
Yes, my lord.
Correct.
Yes, my lord. Back wages and my lord, and the notional benefit and consequential benefit, my lord.
That's okay. So
Yes, ma'am.
it's only back wages.
Yes, my lord.
Essentially, it's a back wages.
Yes, my lord. Last 28 years, he was not in service, my lord. From 96 to till date, my lord, he was not in service, my lord.
But notional benefits will continue to get.
Yes, my lord. But
That para 17 only, that part at this moment.
yes, my lord.
When you, but this order will have effect from, you have not yet reinstated him in service, I believe.
Yes, ma'am.
So you have to give him appointment since 2023.
2000.
Immediate. You have preferred the appeal belatedly.
Yes, my lord. That
So-
was condoned, my lord.
Immediate effect. He has to be appointed as a constable with immediate para 17.
Yes, my lord.
That you have not done,
Yes, my lord.
that you have to do immediately. You have to have that person, you have to give the benefit from 17/8 to 2nd of August to 2023. But the period he was not in service, that will be stayed. That you need not pay disability, but you have to give him appointment since to reinstate.
This will be condonation effect. Sorry, writ appeal. And we say again, let it come to the writ appeal. And we say again, let it come to the appellant. It may be mentioned that in the connected interlocutory application for condonation of delay, being IS Civil 257 of 2024, the respondent has not appeared despite service of notice. Full stop. The delay has been condoned by order dated 28/6/2024, and accordingly, this appeal has been registered and listed. Full stop. Right. Letter notice issued on the respondent, returnable in 4 weeks. Okay, please, postal receipt. Okay. Interlocutory application for stay. This is IS Civil 2294. By usual process. You can serve him by Dusty now.
Yes, my lord. Yes, ma'am.
Dusty can be served.
Dusty, my lord, I can approach the petitioner counsel also, my lord.
No.
Or Dusty. Yes, ma'am.
And his residence.
Once he reinstate, my lord, then we can Dusty, my lord. His address is in 2000.
Then usual process. Make it usual.
You can Banaras, my lord. His address.
Okay, usual process. In the interrogative application, Mrs. A. Gahan, Leonard CGC, appearing for the applicant. This interlocutory application has been filed for with the prayer for stay of the operation of the impugned order dated
Wait, 23, review petition 18 and 20.
dated 6/6/2023, passed in WPC 4718 of 2008, as well as order dated 2/8/2023, passed in review petition number 89 of 2023. Next. we take note of the fact that take note of the fact that the learned single judge, it may be stated that the learned single judge had granted relief to the petitioner in view of the earlier order of this court dated, the earlier judgment and order of this court dated 10/5/2018, passed in WPC 4517 of 2008, and the dismissal of the connected of rate appeal number. What is the rate appeal number in earlier case? Rate appeal 120 of 2019, which was preferred against the said judgment. For the purpose of granting relief in WPC 4518 of 2018. Sorry, 2008, 4518 of 2008. It may also be stated that the petitioners in both the aforesaid rate petitions were charged for same offense of same set of charge is the accordingly, without prejudice to the applicants in the connected appeal, the court is inclined to stay the operation of only that part of the order dated 2/8/2023, passed by the learned single judge in WPC 4518 of 2008, insofar as it relates to payment of back wages for the period the respondent was not in service. However, it is made clear that the other directions contained in the said judgment, which relates to reinstatement of the respondent in service, has not been interfered with. As well as order dated 2/8/2023, passed in review petition 89 of 2020. This part is not safe. Therefore, it is clarified that there is no impediment in the reinstatement of the respondent in compliance with the order of the court. Which shall be subject to the further orders that may be passed in the rate appeal.
That will be subject to the outcome of the rate appeal, but you have to reinstate him in that case.
Yes,
So that was the immediate order was that which you have not complied with. There was the delay. Only that part has been stayed, that the back wages.
my lord, seniority also that is also directed to
That
protect
will
the.
be only the back wages because he did not work during that period.
Yes, my lord.
But seniority, all the notional benefits he will get, he will entitle for. And it will be subject to the outcome of the rate appeal.
Happy to go. Yes, must have.
Probably his colleagues are already promoted to some higher post, no longer a constable. At that point of time, he was working as a constable, right?
Yes, my lord.
So whatever is entitled at this stage, he'll come for that stage.
At that time, he was behind the bar, my lord. That is.
No, his colleague has been already promoted to certain place, right?
Yes, my lord. Yes,
Your colleague,
yes, my lord.
good constables,
Yes.
you have to reinstate him in service in that particular post where his colleague is now working.
His colleague was not behind the bars.
We are not behind the bar. Colleague was not behind. Only this writ petitioner may not be changed.
Petition is-
Only this this petitioner. They are
That thing, no further benefit means
That part you are not staying.
my lord. My humble sir, seniority on all this that be subject to the outcome of the resettlement. Only that.
Already said.
Yes, ma'am.
already ordered.
Only yes, sir. Must
Everything
have
will be
that.
subject to outcome of the decision, but in the meantime, for the time
Reinstatement.
being, we are not giving it.
Must have.
Right, please, Lordship. Lordship, in this case, I am appearing on behalf of H. Gupta, Lordship. Lordship, here the matter is the respondent, Lordship Joint Venture Company participated in the tender process by the railway, Lordship, but their technical bid was rejected on the ground of non-submission of power of attorney by the joint venture company. Therefore, Lordship, the Honorable Single Judge held that since the constituent of the joint venture company submitted the bid on behalf of the joint venture company, Lordship, therefore, power of attorney is not required. Only if any person other than the constituent member submits the bids, Lordship, in that case, power of attorney is required. Lordship, in analogous matter,
This is what is this Oriental PKB JV?
the joint venture company, Lordship,
It's a joint venture.
Lordship,
What is the constitution?
Lordship,
They are both either proprietorship or partnership firm.
it a proprietorship, two proprietorship firm, Lordship, they have jointly
No, it is not required. This is a partnership firm, a proprietorship firm.
proprietorship firm, Lordship.
It's a proprietorship firm. You don't need a power of attorney.
Lordship, as per 1.4 plus 1.4,
Where is that?
Lordship,
Where is
page 71,
It's 71.
page 71. So in analogous matter, Lordship, Honorable Division Bench has already issued notice and passed the order.
Yes, what do you have to say?
Yes, my lord, appendix 2.
Page.
My lord, I have brought the entire tender document. This is with me. Your lordship may kindly peruse. I have 2 sheets. I'll be taking your lordship to the specific area directly. My lord, appendix 2 at page 14. Page 14 of the tender document. The heading of the appendix 2 says guidelines and conditions for joint venture.
Yes.
And below that, it has been specifically mentioned that guidelines and conditions for joint venture. So lordship may kindly come to 1.4 below. The tender form shall be purchased and submitted only in the name of JB, not in the name of any constituent member. And the tender form can, however, be submitted by JB or any of its constituent members, or any person authorized by JB through power of attorney. So when a third party comes into picture, apart from the JB itself or the constituent members, then only power of attorney is required. So this is how it is written. At just below that, at point 1.5, it is written a copy of memorandum of understanding, that is the MOU, duly executed by JV members on a stamp paper shall be submitted by JV along with the tender. The complete details of the members of the JV, their shares and responsibility in the JV, etc., particularly with the reference to financial and technical and other obligations, shall be furnished in the MOU. So what is directed, my lord? This is an MOU. MOU is required whereby a joint venture is constituted, that is to be submitted. So in the next page, my lord, at page 15, this is very important, my lord. 1.10, clause number 1.10. I have underlined the relevant portion. I am reading the relevant portion only. The documents pertaining to each entity, including its fund, shall be furnished to the railway before signing the contract agreement for the work. In case the tender fails to comply with the stipulation within 60 days of issue of the LOA, contract is liable to be terminated. That means all documents pertains to the entity is required to be submitted with the authority within a period of 60 days from the date of issue of the LOA. It is specifically mentioned, my lord, at clause 1.10 at page 15. And at the last clause, 1.13, at the same page, it says the documents to be enclosed by the JV along with the tender. The very specific heading is given, documents to be enclosed by JV along with the tender. 1.13.1 is not relevant, but relevant, I am taking your lordship to the relevant clause, that is,
Where is
at the-
appendix, where is appendix 3, clause 21?
appendix,
Appendix 3, clause 21.
yes, appendix 3, my lord, in appendix, in appendix, there is no such numbering probably. It starts with A. In the tender document that has been downloaded from the, that was provided to us by the railway authority,
Just a
appendix 3 is available. Appendix. Not yet. It is at page 25, my lord, of the tender document.
Where is the rejection order?
Lordship,
Where is the rejection order?
rejection order is at page, Lordship, 99, type copy, 99, Lordship, 99. And that is the original, Lordship, the Xerox copy.
100 is the
It was
original.
submitted by the Phanindra Kumar Boisha. He was the constituent of the joint venture company, Lordship.
Then you don't have a case.
Lordship, as per page 72, Lordship, Roman 21.
When
Page 72, Lordship, Roman
Please,
21.
Devi, kindly tell us, the tender was submitted in the name of JV.
Yes, Lordship.
The tender was purchased by whom? One of the constituent members.
Constituent member.
Then what is the requirement of power of attorney?
Lordship, since constituent member has no individual identity, Lordship, when they are in the joint venture.
that is your interpretation.
Can we read
Lordship,
that particular paragraph?
Lordship,
That clause,
page
clause 21, appendix 3. Read very slowly for your understanding and our understanding.
Lordship, in appendix 2, Lordship,
Page 72.
72, it is stated that if the tenders are JV firm, all the documents like MOU, JV agreement, affidavit, power of attorney, etc. are to be submitted together.
Read clause 1.4 first. At page 71. Okay, one by one. That's your case, right?
Yes, Lordship.
Please read.
1.4.
Hmm.
The tender form shall be purchased and submitted only in the name of JV
So it was done, submitted.
and not in the
it was
name.
purchased in the name of JV.
It is not in the name of the constituent member. It is by the constituent. In this case, Lordship, constituent member has purchased and submitted the tender, Lordship.
There are two parts. The tender form shall be purchased and submitted only in the name of JV.
JV and not
in the name.
not in the name of constituent member,
Right.
It was in the name of JV.
but by the constituent member in this case.
Come to
Next
that.
part, next
Come
part.
to that.
Yes, Lordship.
The tender form can however be submitted
By JV
by JV
or
or
any.
any of its constituent member.
Yes.
Or any person authorized by JV through power of attorney to submit tender.
Lordship.
Now come to 21, next page 72.
Lordship.
If the tenders or tenders maybe are JV firm, all the documents like MOU, JV agreement, affidavit, power of attorney, etc. are to be submitted together.
Yeah.
Now, where is the illegality on the part of this bidder?
Lordship, first of all, as per 1.4, Lordship, the tender must be
What is the ground of
purchased and
rejection?
submitted
What is
only
the
in the
ground
name
of
of
rejection?
JV, Lordship.
Where is the ground of rejection?
Only in the name of general, in case of constituent member.
No, you see page 99. It is not your case that the tender was not submitted by JV. Page 99.
Page 99, Lordship. But power of attorney was not.
No, please respond to what we are asking.
Lordship, Lordship.
Transfer
Correct.
rejection 100.
Yes,
The
Lordship.
question is, was the tender submitted by JV? What is your answer?
Power of attorney of JV not submitted.
What is your answer to the court query?
Lordship.
Court query for the third time is, was the tender submitted by the JV?
JV,
Who
Lordship,
submitted the tender?
constituent Lordship, the Phanindra Kumar Boisha,
On whose behalf?
on behalf of JV.
So,
But in that case, Lordship, JV requires to give them a power of attorney, Lordship.
why? Where is that required? Is not this person, is that constituent member of that JV?
Constituent member, Lordship.
Then
But
This
since,
JV, we can tell you, we cannot teach you.
Lordship,
It is for you to understand. We can't make you understand.
Lordship,
We are dismissing your appeal.
Lordship, it will be taken up next week, Lordship.
Why? You just read again. We are reading for you. We are reading for you.
Lordship,
Tender form can, however, be submitted by JV or any of its constituent member.
Lordship,
So this person, Mr. Busho, is not a constituent member.
Lordship.
He's a constituent member. So he can submit.
Lordship.
There is a word or inside.
Yes, Lordship.
or any person authorized by JB through power of attorney. Now, this particular gentleman, Phanindra Kumar Vaishya, is the constituent member of the JB. So he's being a constituent member, he can file it, he can submit this standard document. Where is the illegality? Where is the requirement of power of attorney?
Lordship,
As per this clause 1.4.
Lordship, in this case, page 113, Lordship may kindly see 113, this is our clarification by the authorities, Lordship, in this case. 113, Lordship, 113.
Or any person. It is not any person submitting, it is a constituent.
Probably, so that the validity of
You
authorized
have a copy
signature.
of the tender,
Lordship,
you have a copy of the tender of the petitioner.
Lordship.
Where is that? Show us the copy of the tender of the petitioner.
Lordship,
Does it say it was not, does it say it was not submitted? You come to your page 99.
Lordship. Yes, Lordship.
Supplier name, Phanindra Kumar Vaishya.
Lordship.
He has submitted.
Phanindra Kumar Vaishya is a constituent.
Constituent.
Now please read 1.4.
Lordship.
What is the meaning of or?
If you can show that it was not purchased in the name of JB, that is something different. But that is not your case.
You see, let us take one horrible example. I'm good in giving horrible examples.
Lordship.
I'm giving you one. The government today has given time that now it is 1.03. It says that if a husband or wife applies by 1.05 today, he will get a plot of land. Either husband or wife. So now the husband goes and applies. Now, will the government say that give you a power of attorney of your wife? What is the meaning of or then? And it says that if third party applies, give a power of attorney. So now husband goes and applies and the government rejects it on the ground that affidavit, what you call, this power of attorney is not there. Is it applicable? No.
But in the first line, since it is.
No, that's okay. This is our concern.
And Lordship, since similar matter is pending on, it is fixed on 18, Lordship.
No, we are not giving you that answer.
Similar matter, whatever.
Same, Lordship tender process.
We are not,
And on
we
the
don't
same
know.
ground, it was
We don't know.
rejected.
So far as merit is concerned, we don't find a merit. It doesn't warrant a for notice.
And also, Ms. Devi, one thing you should understand.
Yep.
It is not that case. If you read the 1.4, it is very clear. Any person authorized by JB through power of attorney to submit the tender.
Yep.
Right? That is the last clause.
Lordship.
This man who has submitted the person is not any person. He is a constituent member. So constituent member can submit.
But Lordship, whether there is any authorization, whether he has.
Give a reasons. We'll give a reasons. At 2 o'clock we'll pass. What is it?
Authorization is in the MOU. In the MOU.
Lordship,
We'll pass.
Lordship, maybe taken about 18-9, Lordship, since H. Gupta is.
Case of the case is different.
You see, you should have taken adjournment at the first blush. After we read the documents, open our mind, then we are not joining it like that. At 2 o'clock, we are passing orders.
Sixteen, 17, and 18. A similar matter was fixed on 13 on my lord this month. These are the similar. It has been fixed on my lord 13. So let the matter.
Do you have the number?
Yes, Lordship, this is the order.
But this is the earlier order, next order I could.
There are three Lordship writ petition. in the
Earlier also, by another group of people.
all Assam Muslim Marriage and Registered Association and another person.
1935.
1935. The repealing act, they have been challenged. We have already been filed.
Okay. So
We already
16,
been filed.
Mr. Rashid, do you have any objection?
No.
These are connected matters.
It's connected Miller. I want the same Miller. They should be connected.
Now, when it is fixed?
13 August, Tuesday.
Mr. D. Rashid, counsel appearing for the petitioners. And Mr. J. Hendik, and standing counsel for the Revenue and Disaster Management Department. Respondent, as well as Madam Namli, comment submitted that issues involving same issue, same writ petition involving similar issues are fixed on
13/8.
And they have jointly made a prayer that these matters also be listed along. This is a being WPC number 25962024, 29112024,
216.
and 216020. Okay, on 13. Prayer out.
Only one of the case we already filed our affidavit.
Doesn't matter.
Only one, my one, only Miller probably notice if we reach
We
only.
will not issue anything.
Oh my.
Obliged, you know.
Lordship, I have a prayer, Lordship, since already notice in another matter, notice has been issued, Lordship. It will, if
See-
adverse order is passed, Lordship, conflicting, Lordship, there are some conflicting, Lordship.
It cannot be. See, we have read together. We have also made it for you. We have also read, right?
Because,
So-
Lordship, if it goes to the merit, Lordship, as per 1.4, Lordship, first line is no constituent member shall purchase and submit the Lordship.
Kindly show us that it was purchased in the name of some.
It was purchased in the name of joint venture, Lordship, but submitted by the constituent member in individual capacity, Lordship. Unless, Lordship, power of attorney is not given, Lordship, he may, Lordship,
Are David alert? CPC appearing for the
appellant.
Like mark. Doesn't do paper.
Only on the explanation of the Lordship clause is required. If both the cases are taken up together,
Miss Devi, we have heard you. That's
Lordship.
all.
Which is page rejection
71,
99.
99.
99. Okay.
Urua. Appellate. As well as
Strengthen.
are
Sharma.
done it on the was appeared by filing KVA. Will to keep it. Keep it lengthy. That's good. Keep it lengthy. Filing this intercourt appeal. The petition, the appellant have say the order dated 25/6/2024 passed by the WPC 3/1/24. The competent authority of the NF Railway had issued the packet tender by tender notice number CON of 2024 FTP 03 heading tender number C dash CON dash N dash A dash MIS dash 2024 dash 02 following work 104.
No, 104. Okay, from 104.
Which one? Ms. Devi, Mr. Sharma, take your seats.
Yes.
The fact that not dispute is that that on behalf of the respondent, which is a joint venture in the name of Oriental that EKB in the JV, the constituent of the said joint venture, namely Mrs. PHA Kumar, the proprietor, had completely been on behalf of the bid was not accompanied by a power of attorney. And on the said ground of the tender committee
by a memo dated 24/6/2024. Last page is eight. Last page is that memo.
Lordship.
Election committee recommendation.
Lordship,
Last page 116.
yes, Lordship.
Found the content as not eligible. With the remark that the power of attorney of the resulted by this page 99 was the
99.
internet. What is the internet? 99
APS.
Yes, that was downloaded from internet. That was communicated to us.
the website. The rejection of the technical commercial bill of the response to the court
176.
indicating that the bid was rejected on the ground that the power of attorney was not. The agreed respondent had filed a petition that says the rejection of technical bid of the submitted by the respondent. After hearing the current site, the current civil court held that the disqualification the technical bid of the respondent at the tender committee was not in consonance with the harmonious reading of appendix Roman 2 of clause 1.4 and appendix Roman 3 clause within bracket Roman 21 small bracket. Result of was held that the qualified intellectual that the letter of the content herein and the actual fact is accordingly set the type and the content were affected for the appellant herein were affected to open the tender of the respondent managed to bid of the and thereafter consider need of the factual along with other factual particular indicated above agreed by the present standard CGC has referred to the various tender clauses specifically clause 1.4 of appendix 2 as well as clause 20, clause 21
Didn't make it. 14.
Appendix 3. It is the submission of power attorney was a mandatory requirement. And therefore, as the respondent did not get the power attorney, there was no infirmity in the technical bit of the response. The both state tender clauses, relevant tender clauses are extracted. Submission of the current CC of the effect in a typical petition. Is in the present is also subject matter of determination in WA 246 of 2024. Was made return on the May 24. That notice the issued in the for contract responded and made his submission for a order included in the and in this this submission of the responded has produced a paperwork containing the document specific to the relevant tender clauses. The appendix that the TC there. Paper. We have already indicated above that the on this fact of the case is that on behalf of the joint venture, Mr. Anindra Kumar Vishnu, as a proprietor of Essence,
Farm name is Phanindra Kumar Boista. Phanindra Kumar Boista individual and the farm name is also Phanindra.
tender. Is the same is also confirmed from the rejection note, which has been quoted by the NFRA authority, where the supplier's name is mentioned as Anindra Kumar Gupta. Therefore, there is no material got in the in this memo. It is more that the that on behalf of the respondent, the tender was submitted by a third party or by any person who was authorized by the joint venture submitted. From the plain reading of the provision of clause 1.4 of appendix 2, we find that in no uncertain terms, it has been provided that the tender form has purchased and submitted only in the name of the joint venture and not in the name of any constituent member. It is not the case of the appellant that the tender was not submitted by the joint venture, but submitted in the name of constituent member of the joint venture. He said clause 1.4 further provides that the tender form can, however, be submitted by joint venture joint venture or to any of its constituent member. Number 3, sorry, or then number 3, any person authorized by joint venture through power of attorney to submit the it is not the specific case of the appellant that the authorized person also the joint venture had submitted the tender not accompanied by a power of attorney. So therefore, from clause 1.4, we are inclined to hold that the learned single judge did not misread or misconstrue. He said clause 1.4 and accordingly the first we don't find for finding by a particular single judge that the disqualification of the technical bid by the tender committee is not found to be in consonance with the erroneous reading of appendix 2 clause 1.4 and appendix 3 clause 7. As clause 1.4 of appendix 2 permits constituent of the constituent member of the joint venture submit counter with the finding by the there was no necessity to commit any fraud. Law being followed by the court in connection with writ appeal and what we call inter-court appeal. Since the decision of the court in the case of Assam State Electricity Board versus Surya Kanta Roy in bracket 1994, bracket was 1 GLR 383, decided way back on 5/8/1993. Is that unless it is found that the exercise of discretion by the Learned Single Bench was arbitrary, even if the if in courts of inter-court appeal, court comes to a different decision, it could not be a ground for interference with the victim of the therefore could not be fact for paragraph 4 of the said judgment. The next the criminal stand civil pronouncement is also found in the judicial report reported in
Right.
1 GLR 117. It is not correct. So the 1 GLR report on the case of N. Ramachandra, RAMA, CHANDRA, Reddy, RWP, Process State of Telangana, in bracket 2020. SSC 478. Where it has been held that unless the appellate bench concludes that the findings of the learned single judge are good, it shall not disturb the section. Review of the said chapter. The data. Supreme Court of India. In the interpretation clause 21. Appendix of the without this decision, I have taken up. Yes.
My lord,
May not be appropriate.
in our writ petition, paragraph number 14, we clearly stated the grounds of
Then we
being
admit it.
mollified,
Then
the
when we
authority
give
being.
notice, we admit it.
No.
Why? Because we have to hear you. No.
Yes. Apply.
May it please Lordship. My Lord, here the learned signatures, my Lord, while interpreting various terms of the contract, my Lord has directed the respondent to the appellant to make payment, my Lord, to the petitioner contractor. Petitioner filed the petitioner making some contractual dispute. My Lord, since the learned signatures has given a definite time frame, we made payment of rupees 49,93,234. But my learned signatures has, my Lord,
We are not. We are not following your chain effect.
Well, there are
projection.
various other contracts similar with the same terms. We follow the same terms, tender clause throughout the country. So, the learned single judge has interpreted a particular term of the contract differently, which is likely to affect some other contracts also existing. And there are other cases pending also with regard to
Which page?
My Lord will kindly come to page 124. 124.
No, where is the imprint order? Earlier we heard.
Yes, the Lordship heard the matter. The Lordship, in fact, the Lordship heard the matter. while condoning the delay.
Ah.
So only thing, my lordship will, my lord, examine the matter now, my lord, nothing.
Where is it, impugn order?
Impugn order is at page, my lord, page 178. And 182 is the direction, my lord. We made the payment because there is a time frame given. It is only because, my lord, the terms of the contract are differently understood, my lord. That's why, my lord, we want to, the lordship may like to examine this only. Payment, petitioner has got the payment, my lord. Only lordship may like to examine this matter because the contractual terms are there, my lord.
But why it was reduced, we don't find any reason.
My lord,
You see the.
my lord, it happened like that. Petitioner was appointed for transportation of food grain from the railway siding to a godown. And in between there is a way bridge. Now, my lord, the petitioner has to take his vehicle first to the way bridge for taking tear weight. My lord, and then go to the railway siding, loading the my lord, food grains, goes to the way bridge again for weighing, and then goes to the ascent. We are not paying for the empty vehicle. That's under the terms of the contract. The terms of the contract says that it should be payment will be made on actual weight of the food grains, and the payment will be per metric ton per kilometer. So if it is a empty vehicle, there is no question of per metric ton, my lord. Therefore, only 1.4 kilometer we are not paying. Lordship will kindly have a look at that
1.4 kilometers is the distance
between
the
way
empty vehicle
bridge,
to go to
way bridge to this stairway, my lord, the empty vehicle which they takes to the railway siding, that we are not paying. That is the only dispute.
The FSC Sudhari summons did not appear today. It appears the Sudhari appeared. Amount has been paid. As per the circular announcement, the amount has been paid. Thereafter, TDNK or notice to issue one. Notice when we come to corporate admission, you say there is no contract. Who is Miss J.S. Das?
My lord,
Who is Miss J.S. Das?
junior Mr. Chinmay Chaudhary.
They file color number.
They appeared, my lord, because they also earlier questions appeared. While, my lord, the application for continued delay was considered, they were hard, my lord.
Oh, no, this is your wakalat
Only after hearing them, the delay was condoned. Lordship will recollect.
No, in this writ appeal, notice was not issued.
Notice was issued, they put appearance on the last occasion.
Affidavit is also filed.
Huh?
Affidavit is also filed.
Yeah.
But
Yes.
formal order of
Yes, yes,
Notice is not there. Affidavit in opposition is also filed.
yes, they have filed.
But formal order is missing somehow. So will today issue notice. Formal is also formal because they have already filed their affidavit.
But Mr. P.K. Roy, and counsel, senior counsel assisted by Mr.
S.K. Chakravarti.
Sorry, P.K. Roy, not Chaudhary, P.K. Roy. Another senior counsel assisted by Mr. S. For the appellant or appellants.
For the appellant, fellow. Appellant.
The sole respondent remain unrepresented today. However, the respondent has already filed its affidavit in the matter in December on 26/07/20. Issue notice returnable by 2 weeks, as the sole respondent has already appeared in the matter and filed its affidavit. Therefore, no formality is needed. During the deliberation of the matter, Mr. Roy, learned senior counsel appearing for the appellant FCA, submit that actually we could put it on I to commit to put it any level of petition. Deliberation of the matter. That in pursuance of the order 26092019 past it WPC number 488/2019, the appellant has already paid the entire dues payable to the suitors
Yes, 49,93,235.
amounting to rupees
49 lakhs
93,
93,235.
when
Well, the date,
do you have the date with you?
date is date, exact date is not, but then it was paid within time.
Paid. Just a minute, it may be available in the affidavit. Let us see.
Yes, in the last petition,
Probably it might be available.
there was an internal system that.
No, no. Might be.
Yes, my lord, it was regional office directed payment on 18/11/2019.
There is a contempt for non-payment, right? That you have paid at year after.
Yes,
Already
apprehending, we
Full
paid.
payment. Returnable to its police account.
Give to them.
Lordship, in item 22,
I filed my wakalatnama today for all the respondents, Lord. And I need to obtain instructions in this matter.
In which item you are appearing?
In item 22, I appear for all the respondents, Lordship. I have filed my wakalatnama today,
You are appearing for Hindustan Petroleum
Lordship.
in item number 22.
Yes, Lord.
What is the item number 23, Mr. Sharma?
It relates to the same order, Lordship. And both of us have
With
prepared.
regard to the single order of the learned single judge, the
Lordship.
petitioner has also filed an appeal and the respondent also are filing an appeal.
Lordship.
What's your good name, ma'am?
P. Hazarika.
Both the appeals have originated from
Order
the judgment and order dated 24/11/2023 passed by learned single judge in WPC number 6506/2013 within bracket Abhijit Kumar Borua versus Hindustan Petroleum Corporation Limited and three others. Second appeal, 20, 23, 20, the appeal, connected appeal preferred by the HPCL in said judgment and order. Preferred appeal, connected appeal number Friday 40. Notice have already been issued on 21/02/2024 and the effect and operation of the interim order dated 24/11/2023 passed inside WPC number has already been stayed, but the said order dated 21/0.
In the other case, there was an IA file for condonation of delay.
That is in the
Item 22.
the Mr. MP Sharma. You have filed today
Lord.
in the IA.
No, in the IA, I said that I had the instructions to appear. Lordship, on that day, Lordship, that appeal, that I was admitted and the delay was condoned since the days were not much, Lordship. And on the appeal was admitted.
Right.
Was listed.
Today, Mr. MP Sharma, Grand Counsel for the respondents. Number
All the respondents.
1 to 4
Lot.
have entered appearance by filing as such notice annually as such.
Okay.
Notice issued to the respondent as Mr. Ambition preparing a counsel for the HPCF has already entered appearance on behalf of the Place this matter for admission when
I needed lordship, but I'll have to obtain so instructions, so lordship at least 4 weeks may be given. Lord.
you will file affidavit or you will just
That I can't say lordship, but
yes, ma'am.
instructions would be necessary.
Will fix it sometime after 4 weeks?
Lordship, 3 weeks, lordship, 4 weeks.
You are already restored to service.
Yes, sir.
Your service has been restored.
Yes, sir.
You are there. So
No, no, no.
restitution was ordered.
Yeah, but that
Alright.
is still here.
Alright.
Okay.
On the prayer of the council for the party, list after 3 weeks. On the date to be fixed by the registry. Along with the appeal number 40 oblique 20.